So this is the CPD description that was put in the bulletin. I'm not going to go through it, but I'm just keeping it on this slide deck for record purposes. And what I tend to do is I tend to use these and send them to the Law Society of BC when I put in my annual CPD credit claim. And their approach is to look at the description, and as long as it has certain elements, that's fine. They won't look into it more. Nothing in this presentation should be construed as representing any official statement or opinion of law by the presenter of the Law Society of the Northwest Territories or the Government of the Northwest Territories. Purpose of CPD goals generally is to present substantive law, procedural law, aspects regarding professional ethics, practice management, and lawyering skills. And this CPD is rich in all 5 of those. This presentation was originally made in 2012, and it has been updated for 2023. There has been a fair bit of academic writing and case law since 2012, in addition to some, although limited, legislative reform. This presentation is aimed at a legal audience, but it is generally applicable to all. Not everyone is familiar with IT, and those who know what metadata is and how it is used, this presentation may be of limited value. But that said, the case law considered may be of value in any event, as may some of the themes presented. There is a list of sources, so when the slide deck is available to the members of the Law Society, you will have all of these references, including their hyperlinks. There are other sources that are peppered throughout the presentation with hyperlinks. The objective of this CPD is to present an overview of what is metadata, to alert you as to its existence, to show some methods of controlling the information that is conveyed in it, and to alert you to the risks of inadvertent disclosure. This is the outline of the presentation. We're going through an introduction at the moment. I will describe what is metadata, its relationship to databases and uses, queries and logical inferences, how metadata is used, examples, how it's generated. Then we'll have a quick look at software and hardware aspects of it, caution for the practitioner, how to protect oneself, ethical considerations, and then we'll have a look at some substantive case law. We will then look at e-discovery and emails in particular. There will be an opportunity to look at metadata that is generated in a Word document, and we will explore how to cleanse that. And time permitting, there is some additional information on such things as the national security cases. So we'll start off with a book. Consider a book. So this is a screen capture from the library, Public Library Services of Northwest Territories, and it's a book called The Grapes of Wrath. Some of you might have heard of it. John Steinbeck. And you can see that there's certain bits of information here about the book. So the book is the object, the physical object. What we have here is a representation of that physical object that is virtual, because it's not the physical object. And it's describing certain fields. So we have a record of a book in the library, and things such as item information, title, author, publication date, and so forth are fields in that record. This is a diagram of what is called a schema, and it's actually how a database is run to track all books in a library. And you will see that there's various tables. So these things relate to tables. These are the fields that are recorded. So we have things about the book, the name, the subject, overview, publisher, and so forth. We have something like a book item. So we've got a barcode. Some of these things are related to fields in here. And we have the author. So they've got a separate table for authors. So there could be many authors who write, or sorry, there could be many books written by the same author, or there could be many authors who write the same book, right? Multiple authors. So this is an interesting relationship between these two tables that is being constructed. The purpose of separating this information into tables is called a process of normalization. And what it does is it actually helps improve the efficiency of the search when information is being searched. And it allows you to make all sorts of inferences from those searches. So this is called a relational database, RDBMS. And then there's other things such as the language. There's stuff about patrons. So these are the people who borrow the books, and the librarian who recorded it, and all sorts of things. So it's a very interesting table, and this is actually how a database works. The database is, of course, making use of metadata, which is metadata is, of course, all the fields. In the case of a library, there are standards. So this is an ISO standard or an IETF, Internet something or other task force. ISO is International Standards Organization, and C is American National Standards Institute. I have no idea what an ISO is. I'd have to research it. But this is an attempt to standardize the way in which information is recorded. And what you'll find in databases that are commonly used, there is an effort to try and standardize some of the data so that it can be shared fully and comprehensively. So examples of index keys, for example. So you might have a unique number that identifies a record. Another type of metadata. So for instance, even your license plate number is something like that as your driver's license number or your registration number. Your Law Society membership number is an important identifier. We have international standard book numbers, international standard serial numbers. The VIN, the vehicle identification number that is in 2 places on your car. Your social insurance number. In Britain, they have a national insurance number. Your GNWT employee, if you are a GNWT person. If you have military experience, your service number or regimental number. Your business number for income tax. Same with GST, or health insurance card number, the blue card. Date of birth is another thing. And if you remember from Access to Information and Protection of Privacy Act, all you need is 2 identifiers generally to constitute personal information. So your name and your date of birth is enough to identify you uniquely. CPIC lookup number, so that's Canadian Police Information something or other, I can't remember. Equifax and TransUnion will have numbers for those who are into creditor law. CRA, of course, uses your SIN number. What have we got here? We've got, back to the book analogy, we've got a set of many databases, set of many records. So what I'm doing is scaling it up. So you got one field, you remember, that was one single piece of metadata. You could have a collection of those constituting a record, okay, a set of many fields. And then a set of many records is a database. A set of many databases, you're getting into big data, okay? So metadata is about a person or a book. It's really data about data. So metadata is ubiquitous. It's everywhere. Metadata is data about data. Metadata is structured information that describes, explains, locates, or otherwise makes it easier to retrieve, use, or manage information, an information resource. Metadata is often called data about data or information about information. That's a definition straight from National Information Standards Organization. So I guess I do know what NISO stands for. This is a slide which you can look at your leisure from the Privacy Commissioner of Canada. And it's basically explaining what is metadata. There are different communities use different terms of standards. So I think we had seen the Dublin Core with respect to tracking of books and publications. Here's Mark 21, which is a traditional library cataloging system, which I think might be consistent with the schema that you saw earlier of that library database. Darwin code for biology, and so forth. There's even ones for court management systems. You may have heard of XML, which is a format for documents. So it's tags for documents. And if you think about it, what's happening in XML is it's actually allocating a type of field to a line of text. So it's describing the type of text, and then that is used to format the text in the final publication. LaTeX, if you've ever played with LaTeX, which has been around for decades, it's the same sort of idea. That is another type of publication system, so that when you're thinking about it, the lines of text are actually fields in the database. And then you can take your field and associate that with a type of formatting. And then what you have is a record for that text, which includes the actual text and the format. That is actually how many programs work, including CAD programs, computer-aided design, so the drafting. We're dealing in the realm of big data here. Cookies is another form of collecting metadata about your activities online, and it's used by internet service providers and other entities to track your consumer behavior and your online activities to tailor the ads that appear in Facebook or on Google or wherever, to tailor the ads to suit your browsing preferences, including not just merchandise, but also including political things. So if you start getting advertisements from a political party on your Facebook page, that's probably what's happening. Whenever we're talking about big data, we're sort of creeping into the realm of artificial intelligence. And this is computer programs that do what they do best, which is pattern detection, recognition, and analysis. Diverse use of metadata. So we are talking about automation and computers. And it's everything from statistics, museums, healthcare, geospatial coordinates, word processing, intellectual property, court management systems, I've mentioned, espionage, disinformation, manipulation of elections, and there's a whole mathematical field called taxonomy, which is the field of classification of things into a hierarchy. So it's a big area. Types of metadata. So basically there are three types of metadata. Descriptive metadata describes a resource for purposes such as discovery of identification. It includes elements such as title, abstract, author, and keywords. So that was probably that first table that you saw in the schema of the library database system. Structural metadata includes how compound objects are put together. For example, how pages are ordered to form chapters. Administrative metadata provides information to help manage a resource, such as when and how it was created, file type, and other technical information, and who can access it. There are several subsets of administrative data. Two that sometimes are listed as separate metadata types are rights management data, which deals with intellectual property rights, and then preservation metadata, which deals with information needed to archive and preserve a resource. There are standards for various types of application. I'd already mentioned the Dublin Core Metadata Initiative, and there's various open fora for the development of interoperable online standards for metadata. XML is a classic one, although XML is getting antiquated these days. This is an example of the Dublin Core. You can see it's got things such as the fields would be things such as contributor, coverage, creator, date, description. You can see that there's the rights in the second column, and so forth. This is the Uniform Law Conference of Canada, their old homepage, which has been superseded. And this is the back end of the website for that page. And what you can see is that there's an option just over here for metadata options. You can put in keywords, a description, the author, content rights, and so forth. There are other bits of metadata in here, including the date that it was created is recorded somewhere, probably in one of these fields up here, the date it was published and so forth. So there's more than just this in terms of the metadata that's present. And what it allows one to do is actually sort all of the articles, for example, by their date, by alphabetical order, by the date they were published, by the date that they were modified, however you want. So this is where it starts to come in to web applications. You're probably a bit more familiar with that, Jessica, than I am with the current system, but it's a very, very common approach. So we're still back looking at the catalog, the book catalog analogy. So it's not like the old card catalog system, data on books. If you remember, there was the subject, the title, and the author index. But this is much more because now you have a lot more than just those three fields indexed automatically. It can be embedded in a resource. So for example, bibliographical data in a book or stored remotely. Card catalogs are obsolete, but I suppose they could always fall back if we have, for some reason, the internet went down, but I think that would be the least of our problems. So here's an example of things in the data table. So here we see a customer list, business application. So we've got like the company. You can see that some of these companies are repeated. No, they're not. So this is, or maybe they are. Are there any repeated companies there? I don't see any. Anyway, so we've got a table or a data table, collection of records. So horizontally, we're looking at a record, which includes the following fields: the ID number, a unique ID number, okay, a company name, or the first name of some customer, the last name of some customer, their email address, business phone number, job title. And we have a employee list, an order list, and a supplier list. So this is an example of some sort of customer relationship database. Some of these might be related. So for example, if you have an order that relates to a specific company or a customer. So you can see here there's a field, a customer field, that relates to this customer list. And what is happening or should be happening in a good database is there should be a relationship between those two tables, and in particular connected to those two fields, some sort of link or lookup. Use the access term. Data relationships. So this is another schema, and we can see the relationships in these lines. And you can see that in some cases there's a one-to-one relationship. In other cases, there's a one-to-many relationship. So if you remember, I was talking about multiple authors and multiple books earlier. This is very much in that realm. So this is a screen capture from the Northwind database scheme in Microsoft Access. So if you do want to play with databases, Microsoft Access is considered to be a mediocre database program, but it's a good tool for learning. So we call these relational managed database management systems, or DMSs. The power of the database lies in comparing data tables to data and making logical inferences from them. And this is probably one of the most significant and powerful tools, and least understood, in a personal computer. A lot of people try to use Excel as a database, but it has its limitations in terms of dimension. You can certainly do 2 dimensions on one spreadsheet. You can do 3 dimensions by doing different worksheets relating to each other. But when it comes to infinite dimensions, it breaks down. You're better using a database program. So in Access, and most databases are configured of this way. You have tables, queries, forms, reports, and macros. This is in the workings, the inner workings of the database for database programming. The tables would contain the data. The queries would be the actual logical comparisons between fields in different tables or even in the same table. Forms is the preferred way to enter in data and also to create an interface for the user with the database. Reports are very interesting because that's the information you can pull out resulting from the query. And what you can do is you can sort things by different fields, and that's how you make very interesting logical inferences and comparisons. And then the macros are just macros. It just automates some of these features and the report generation. So, for example, here is a report from a database. I've already talked about querying and reporting. This is not sampling of data. In the old days, we used to do sampling of data sets, statistical sampling, but this is actually an analysis of the full data set. And with computers, you actually have the computing power to do that. In the old days, it was uneconomical to do that because you needed too many cards. Is a foundational principle of how a search engine works, both if you're doing legal research, if you're using tools such as LexisNexis, if you're using Townley, it's also how the internet works. If you're using Google, this is at the core of automation. I've just thrown in a bit of a programming function here. This is some sort of logical comparison that's going on. And you can see the word Boolean here. So we're into the realm of Boolean logic and set theory. So how a query is used in a library project. So this is just a snapshot of some querying language. We're applying logical tests to identify records. That are across several different tables, namely all those items that were flagged for disposal. So this is out of the library project we did in 2016. The resulting data is returned and a list of items is slated for disposal in the courthouse library review. So this tells you basically you're selecting certain records from, and this is, for example, an indication of a table, okay? And this is a field in another table. Catalog query is the table, ID is the field. It is trying to identify what the ID is and all that. So there's a good process here. There is an interface, a graphical interface for Access that you can use instead of direct querying language. This is called Microsoft SQL, Structured Query Language. If you're going to be programming directly in query language, you're probably best not to be using Microsoft Excel. There are better ones around, including open source ones. What does metadata do? An important reason for creating descriptive metadata is to facilitate discovery of relevant information through logical inference. In addition to resource discovery, metadata can help organize electronic resources, facilitate interoperability, and legacy resource integration, provide digital identification, and support archiving and preservation. So some examples, this is from a practice direction from the Alberta Court of Queen's Bench, guidelines for use of technology in any civil litigation matter. And you can see that they've got record and format. So this is an attempt to try and control how technology is used in civil litigation matters. And you can see that that last row talks about an index for agreed exhibit book and the record of pleadings. It has to be a tab delimited ASCII file. So that means that's to make it possible for the opposing party to be able to make use of the digital information and do whatever they want, including some form of analysis. Here we have basically a table, the type of table to be provided, including the format of the fields. And it's very reminiscent of starting a new data table. And here, what I've tried to do is put it together in, well, this is an example of an old version of a database that we were using to track our own legislative drafting projects in legislation division. So I actually use this. The end result, here we have a table of departments in English and French. So we can actually produce a report indicating which departments administer which items of legislation. Here's the Law Society website in 2017. And I had mentioned XML, but here we have HTML language. And this is exactly what's going on here. So all of these things are information or records about certain components that appear on the website, particularly on their homepage. And it is using, at this time, it was using Drupal, which is an open source content management system that was in use in 2017. This is the Law Society website in 2023. It's no longer using Drupal, but it's using some other content management system. But you can see that, again, we have these tags. So you can see them in these square brackets. So for instance, the head, this is the standard type of HTML head again, including locations of things. So we can actually discern from this information the directory structure of the website by the provider. And that's all open source because it's completely visible on the internet. Law Society discussion paper. If you go to this website, you will find the Law Society discussion paper of 2019 that talks about the new Legal Profession Act. And what I did was I just had a look at the properties in the PDF document that's available. And you'll find that we know it was made with Microsoft Word. We know it's version 6, so if we were carrying out litigation on it, we could look back at the previous drafts or at least try to get hold of them. We've got Ian Rennie, this Ian Rennie person involved. We have some dates when it was created. We know it was created in September 23rd. We know it was last modified in 2022. That's interesting. So this isn't the actual version that was presented in 2021 or 2020 or whenever it was presented. Actually, we do know it was, anyway. There's other information here. We know that they were using an Acrobat distiller to print it. There's some sort of version of Adobe Acrobat being used. I have information where this is stored. It's actually stored currently. Okay. And I have the file information size and some other details. So that's all very interesting information. You can also add custom properties. So that's another option, particularly if you were producing the document and you wanted to track some characteristic of it. So metadata facilitates searching, sorting, organization, pattern recognition, and then there's various steps. If you think back to the way in which the back end of Microsoft Access was working, data entry, collection, queries, and then reporting. Who creates metadata? Staff who initially digitize or others create the digital object. It's often automated. It's produced automatically by the software. Sometimes staff are dedicated to the creation of metadata. So for example, a librarian filling out a card or the indexer of a book. Although the index is probably a product. Tools for metadata. So there's templates, markup tools I had already mentioned, extraction tools. You can extract pages in a PDF to a new file, conversion tools, convert PDF to Word. if you take a Word document and convert it to PDF, you now have two documents. You've got metadata in the Word document. Some of that metadata might have been exported to the PDF document, plus you have other information about that particular PDF document as well. On the Canada legislation website, the Justice Laws website, you'll find statutes. This is an inspection of an XML document that's made available on that website of the Farm Products Act. And typically, Justice Laws or Justice Canada website makes available their statutes and regulations in PDF, HTML, and XML formats. XML is the master file, and the PDF and HTML are actually generated from the XML file. So the XML file has different coding than HTML, and you can see it here. And it relates to the way in which it's going to be formatted. And this is embedded metadata. It's automatic formatting of PDF and HTML based on XML data. We do not have that yet in legislation division. It would require some modernization. Here's an example of an image of a painting. And I know automatically, just by looking at this JPEG file, that whatever one it was, I didn't record the name of that particular image, but it's one of these images. I know the date when it was taken. I know that it's a JPEG format. I know its size, and there's probably more information, more metadata information that I can pull from this if I wanted to. But this is the default as to show what's shown in the file manager in Windows. Here's the file properties, and these are all the fields. So you can see that some of them are empty because I haven't put them in, but I could put them in. And if I did put them in, it would facilitate sorting, particularly if I have a large volume of data. What I can discern from the file properties is I know when it was taken, I know the date it was acquired, I know what the camera it was, including the model and the settings. I know that the flash was off. The JPEG file size, the owner of the computer is identified, has not been modified since acquired. And this is the same with things such as your camera on your cell phone. Some will actually take the GPS coordinates of the image, including your cell phone. And if you have your location your location setting on your cell phone, it will most certainly do that, whether it's a GPS coordinate or it's triangulated using the cell towers. Is this useful for evidence, unintended disclosure, an investigative tool? Absolutely. Some options on your phone or your tablet is to deactivate the location setting. And you might consider purging your metadata using your operating system. File properties in Acrobat, you've already seen that. You can there is an option to purge them in that. All software and hardware is affected by this. You're dealing with Office, all of them in Office, WordPerfect, Star Office, and LibreOffice for those that might use open source software. I think it's probably an issue with all software files. Unexpected hardware, photocopiers. Did you know that every single item that's photocopied is retained in the photocopier memory because there's a hard drive sitting in there? Laser printers, cell phones, tablets, game consoles, casino machines. Generally, one cannot turn off the default saving of metadata. One has to scrub the document. Does anybody have a suggestion as to why that might be? No? Okay. Well, it's how files are ordered and how they're arranged on computing systems. So that's why. It's because it's a default. Types of metadata and word processor files. So we've got comments and hidden text, document revisions, annotations, including all drafts, users, comments, styles, undo, redo history, your username, initials, document summary information, header and footer information, hyperlinks, non-visible portions of embedded of object linking and embedding objects. So that might actually give information to other files which have been used. So for example, when you import an image. So that's a caution for the practitioner. Metadata helps productivity and it is crucial for the facilitation of indexes, but the use of search engines or computer file organization. It's very useful for online collaboration, but there is the risk of disclosure, accidental disclosure of business intelligence, intellectual property, impact on shares and regulatory investigation. It could harm the client, it could harm the lawyer. No warning about that this extra information is associated with the document. So how do you protect yourself? So this is a very useful slide, and it takes you to recommendations put out for Microsoft Office. You can see that it only goes to 2010. It doesn't include 365. That slide needs to be updated. You can inspect the document. There's an inspected document tool. And then you can actually remove some of the metadata. There's nothing available for, I'm not sure if that's true. There's nothing available for earlier versions. For Mac, there is a website as well. You can see here that there's a criticism about Macintosh as Word 2011. Users would be best to take it, generate a PDF document, and then cleanse the PDF document. WordPerfect has similar issues. Adobe Acrobat, examine the document. Outlook has special rules regarding email. Web browsers, if anybody has ever gone into the settings, the security settings, or even private viewing is another option. There are third-party scrubbing programs. You can print to PDF, ODF, or GS, or something like that to facilitate the ability to clean the document a little bit more. Or you could just scan a physical copy of the document, but there is still metadata through the photocopier or scanner. Encryption is another method of protecting oneself. Destruction of hard disks. Ethical considerations. So in terms of ethical considerations, I had to update this from the 2012 version because there was a change in the Code of Professional Conduct. So we've got Chapter 3, the relationship to clients. Remember, competence, quality of service, confidentiality, and the preservation of the client's property. And then Chapter 5, the relationship to administration of justice. So there's the evidence considerations, and there is a omission on the part of the lawyer. I invite you to have a read through those. There is a view that keeping up on IT is a matter of competency, and that's partly why the member registration process online is done exclusively online now rather than in paper forms. The reason for that is that it's expected that practitioners are conversant at least with basic IT procedures, such as registration of an online account and then being able to fill out an online form. If they aren't, then there's a competency issue that arises. It poses a bit of a problem for some of the older practitioners who are not very competent with IT. An example is the late Hugh Latimer. But it's a matter of competency. It's one has to be keeping up to date. Legal Profession Act talks about, Part 4 of the code also talks about Legal Profession Act, Part 4 talks about competency and conduct of registrants. So this is the new Legal Profession Act. Section 68 talks about codes and standards. The executive may make rules adopting a code of conduct or standards for registrants. So we're coming back to the model code, or sorry, the code of professional conduct, formerly the model code. Where code or standard is adopted under subsection 1, the code or standard has the same legal effect as a rule. Where a proceeding against a registrant is carried out under Part 4 of the Act and the rules for a breach of a code or standard adopted under subsection 1, a copy or printout of the code or standard is admissible as evidence in the proceeding. And then there's the failure to comply with the code, where the registrant fails to comply with any provision of the rules. The Law Society may commence a proceeding against the registrant under Section 32. So the purpose of this slide was to give an indication as to the legal effect of not following the code of conduct. But of course, the code of conduct is also backed up by the statute. So so this is just a reminder of that, and also of the upcoming legislation. Some substantive law. And so I did a quick search on Canley for metadata, and here's some examples of legislation that actually made use of the term metadata. In some cases, they use meta-data, so it's a different search with different results. But it's kind of interesting to have a look at this and see where these are coming from. Employment and social development, freedom of information, one would expect. And it's kind of interesting, we've got a bunch of mining regulations here, which is unusual. There's a number of writings here. So I'd mentioned that I was providing some additional sources. This is through the Canley commentary feature, and with hyperlinks. And some of these are old, some of them are not so old, and some of them are quite interesting. Some cases. So these are Canley cases respecting metadata, and they were arranged in order of the court, okay, the hierarchy of the court. So we've got the Supreme Court of Canada, and I just put a couple of notes here. So in Cole, we've got a child pornography case, the teacher. One did a warrantless search of a laptop and a disk, and the argument was that the Section 8 charter rights were breached. I think the laptop, they agreed, but not with the disk. In the case of Vice Media, disclosure order on a journalist. In the case of air passenger rights, we're dealing with litigation privilege. In Sauna, dealing with copyright infringement. Bishop, we're dealing with discovery of Facebook metadata for whatever purpose. This should be arbutus, not arbutus. Metadata phishing expedition. Okay, so all of these sorts of issues come up. Stinchcombe deals with disclosure of electronic legal standard for disclosure in electronic form appears to be straightforward. It is a dated case, it goes back to 1991, and I'm not sure that it actually deals with metadata. The Crown's obligation to effect meaningful disclosure flows from the constitutional right of the accused to make full answer in defense. Electronic disclosure is meaningful disclosure if it is reasonably accessible. Now, this is where the metadata comes in. And I would argue that metadata is actually a very important part of the disclosure. And if you remember the Alberta Court of King's Bench practice direction 4, was sort of getting into that with the formatting of the index and the data. Reasonable accessibility is a matter to be assessed contextually on a case-by-case basis, but certainly to be accessible, disclosure must be reasonably organized and searchable. In my view, the importance of organization and searchability increases proportionately with the volume of material disclosed. So this is the tactic of swamping the other side with vast amounts of information and material. The greater the need for the organization and reasonable search capabilities. Disclosure database. So this was another version of a database that I think was brought up in the Stinchcombe. And you can see that we're back into these things. And I think that practice direction I had alluded to was sort of getting at that. In that schema that was in Stinchcombe, they're missing some critical fields if you looked at it closely, such as the dates, the times of email traffic. And this is why I think the 1991 case is probably a bit dated, because those fields are absolutely critical. What information can be discerned from them, who knows? But that information should be available. Header information, we'll come back to that one. Do these, and my question, do these missing fields facilitate swamping? So I think they probably do, but I think you've got to take Stinchcombe in its context, that it's a dated case from 1991. It probably does not consider metadata fundamentally, but still applicable to metadata. Oldby, another criminal case, not all the basic metadata fields were populated, concluded that the database was not sufficiently searchable and therefore fell short of being sufficiently accessible, cannot separate the wheat from the chaff. How is electronic evidence handled in the Northwest Territories? That's a rhetorical question. Does anybody have any thoughts on that? So I think it's handled by in accordance with the case law, and possibly with respect to some of the practice directions in other jurisdictions, which are based on the Sedona principles of e-discovery. So it's probably handled that way. There is no practice direction from the Supreme Court in respect of the handling of electronic evidence at this time. There's a bunch of other interesting cases. So we've got this one from the old G20 process. And we also have some Northwest Territories cases there. So there's that Cockney one. Metadata was accepted into evidence as admissible. Not so in that earlier Ontario case. But it is a regulatory case. It's not a criminal one. There may be different standards. Here in this Alberta case, NMAX, an order by the court for the party to provide unredacted Excel and emails in native format with metadata intact. We've got the Laborers International Union, false photographs with doctored metadata submitted to the board. And then we've got this LTS infrastructure one, which I didn't give you a summary, but that's another Northwest Territories case. There were changes to the Evidence Act in 2019. Electronic record system includes a computer system or other similar device in or by which data is recorded or stored, and any procedures related to the recording or storage of electronic records. So this gets at the authenticity problem of the electronic data, even though that the metadata might be of interest in verification. If the electronics record system is okay, it meets the definition in the Evidence Act, then it should be okay unless you have some indication otherwise that there's a problem. This is an extract from that statute. Proving the integrity of the electronic record system, subsection 7, for the purposes of subsection 5, in the absence of evidence to the contrary, there's that magic wording. And the integrity of the electronic record system in or by which an electronic record is recorded or stored is proven. And then there's a series of things that can be done to prove the integrity. e-discovery. There are specific rules regarding emails. And here's some information about the discovery of emails. We've got Supreme Court of British Columbia practice direction. We've got a generic protocol from BC, Judicial Council, Nova Scotia, annotated civil rules of procedure, Ontario, and then the Sedona conference I had alluded to earlier. We've got this case law, the accessibility versus data swapping, and then this generic protocol in respect of emails. Is the header information in emails reliable? Is that information even relevant? What is that information? And it's contained in this draft protocol. Generally, a document is to be provided in PDF format, images of the document, so you scan it. Okay. Accompanying database with certain fields as is required. Okay, we've seen that a little bit already. All court documents are in PDF format. Lists or schedules of discoverable documents in a tab delimited ASCII file. CSV, I think, was the format, comma, standard variable. The trial record is in PDF format. And the index for a common book of documents and trial record is in tab delimited ASCII file. Required fields for discovery. I'm not going to go through the formatting for Excel. Default format for discoverable documents and electronic material. TIFF is a type of image file when you scan things in with a resolution of 200 dots per inch. TIFF is easily convertible to standard image files, including PDF. If the party to whom this practice direction applies wishes or needs to depart from the default standard, should seek agreement from all the other parties to an agreed protocol. So they're very much leaving it up to the parties to decide on the format. Jurisdictions, so here's some more information about practice directions in other jurisdictions. In the Northwest Territories, we've got practice directions that set out a URL, but none are enforced in respect of e-discovery. I don't know if that's current. Given the practice in these other provinces, could a case be made that these practice directions apply anyway, because there is a certain amount of harmonization? This is the LTS case, and it seems to support the Sedona principles. Selected cases in Northwest Territories, so there are 12 cases, of which 4 might be relevant. In Fukuoka, it's 2008, relatively old case. This is that swamping issue, but again, it's restricted to physical documents, a reflection of its old character. May, carrying permission from a conditional sentence supervisor. So as long as it was in electronic format, that's fine. Is permission on your cell phone is sufficient? Probably. And then we have some commercial case here, and then another one about swamping. Swamping with data is just as bad as illegible documents. We have an IPC case, so this is the Privacy Commission, the Information and Privacy Commissioner. It was an HIPAA request that documents be disclosed in electronic format, and it's an interesting case. There's problems with it though. It may facilitate a fishing expedition, swamping the provider as well as the recipient in the court. There's a risk of inadvertent disclosures, for instance, from metadata. Lack of any legal requirement if the judge is not correct, the issue can be put to a judge. So there's privacy issues here. What is the header information in an email? After a message is sent, there's a processing that happens where it gets routed through various nodes throughout the internet. And the header information provides all that information. So in terms of leading cases on header information, we have this IPC one. Well, we've got 3 IPC ones. So under section 67 of ATEPA, just how much legal effect do these cases have? I would put that to you. I don't think they have much legal effect, because if you look at the wording, they're all recommendations. They're not orders. And section 67 of the Act, I don't think that the Privacy Commission actually has capability of issuing orders. And so are all of these cases facilitating fishing expeditions? I don't know. So here's an example of an email in Outlook. Liz Jackson from 2015. Okay. This is in the PDF file. Okay, it generated into a PDF file. Metadata is not particularly interesting because it's metadata about the PDF file. But if we look at the header information, there is a feature in Outlook to go to the file tab, and then you look at the properties. And here is the header information. It's in that window in the box at the bottom there called Internet Headers. And what is that information? Well, this is a cut and paste of all the information in that box. And what it is it's the routing information from me to Liz, and from Liz to me. So details of all the servers involved, including IP addresses. What use is that? I don't really know what use it is. If you were doing a forensic investigation into whether or not the email is authentic, I suppose perhaps that and the properties of, or the metadata might be of interest, because you might be looking for inconsistencies. That's the only thing I can think of. A good question is, did Liz know that all this information is in her email? I certainly wouldn't. The practice of providing false information in message headers is a growing problem. This is also known as spoofing. For example, a message might indicate it is from Eric Lang at Alpine Ski House, when in fact it is actually from my bulk email service that promotes schemes to get rich quickly. So you've probably had some of these phishing type emails and whatnot. The fake email address is it's called spoofing. Therefore, before you send a complaint response to someone about his or her message, remember that the header information might be forged. So I've certainly had email traffic from somebody purporting to be the president of the Law Society of Northwest Territories by name, and it was false, completely false. I could tell just by the content. Power versus Moss, there's a bunch of cases about the unreliability of header information, including one from the Supreme Court of Ontario. Not of high authority, but not bad. You can see that privacy commissioners are also dealing with this. Now, be cautious when you're looking at the IPC type cases, because they may actually have capability of issuing orders. Here we have another order from Alberta, privacy, when it is legitimate to withhold disclosure of email address or recipient information. There's an angle there that one could get into on the provision of information. So, for example, in criminal cases or family law cases. And the IP header format is more of a technical thing. Much of the data is for error checking and to verify integrity of email. It's easy to manipulate, and thus spoofing is possible. This is probably the reason why service by email is not acceptable under the Supreme Court rules unless by prior agreement by the parties. Is the header information data or metadata? Is the header data about data or metadata? In a way. Just how reliable is it as evidence? Think back to the IPC cases, phishing expedition or due diligence by authenticating, or at least having the opportunity to detect inconsistent metadata. To try and identify a suggestion that the file's been altered. It's sort of like evidence, but it sort of goes into the argument, well, you should show it if you have nothing to hide. It's inverting it's assuming that it's false before any sort of proof of evidence to the contrary. Anti-case law. So again, we've got these IPC cases. This involved a union. There were slight differences in the header information on this record. The body of the email is the same as the one in which it appears, which has already been disclosed to the applicant. This copy of a record also includes an attachment, which was disclosed, okay. I recommend that the email and the attachment be disclosed to the applicant without editing. So there has been an inconsistency in the header information, and the privacy commissioner, she picked up on it. But if I were running a case, like a proper case in a court, I would be looking for inconsistencies in the evidence, because that's an indicator of something, and it helps formulate my theory about the case. Is this approach reasonable? So this is a criticism of the IPC decision or recommendation. Reasonable, cost effective, where thousands of documents are involved, or millions. So this brings us close to the end. I have some extras. First of all, are there any questions?
Hi, Ian, it's Simone. How are you? Oh, let me start my video here. I have a question. If you were to recommend one takeaway action that you think is the most important action that we can take to protect ourselves going forward, right? When we leave the CLE, to say, well, we really should be wiping the metadata from, our documents in this way, or really it's, the emails and what's in there. What would you say is the most key recommendation coming from all of this really important info that goes across all parts of our practice, that you'd say this is the takeaway that I hope you all do when you leave this CLE? And also, is it different for solicitors versus litigators? That's my question. Thank you.
I think when it comes to sharing of documents with adverse parties, perhaps even other parties, you should really consider whether or not you should be cleansing the document of metadata, particularly sensitive metadata. And I'm going to go through an example of a WordPerfect document next. That's part of my exercise here, first point here. So I think that's probably the most critical one. For those who are making use of metadata, it's there as a tool. If you do find interesting metadata, you should ask yourself about the ethical aspects of it, whether it was unintentionally disclosed to you, and whether or not you actually have an ethical obligation to inform the other side and also disregard it. I don't have the answer to that. That's probably a case-by-case basis, and it's something that you will have to grapple with as a practitioner. So does that answer your question?
Yes, thank you. Yeah, I'll look forward to the exercise.
Are there any other questions or comments? Okay, so in terms of the exercises, I was going to do a demonstration of cleansing a Word file of metadata. We'll do that in a minute. I was going to explore the lending library example database in Microsoft Access, but we're not going to do that because I don't have access on this computer. It was sort of an enrichment thing. And then there's also extra materials, the national security cases, which we could sort of browse through. They're always fun and amusing. But let's have a look at the demonstration first of all. Okay, so I'm going to, what am I going to do here? I'm going to change the share to my Word document. Can everybody see the Word document? No. It's not there. Can everybody see the Word document?
Yeah.
Good. So this is a letter. This is a letter that I prepared in Word, okay? So it's got an interesting date. It's so here it's going to this lawyer. Who's it from? It's from this other law firm. Thank you for your letter to disclose financial reports 1 week before their public disclosure to U.S. Security Exchange Commission. We are pleased to provide this information to you below and hope it will be of assistance to your endeavors. If there's anything else we can do to assist you or your client, please contact me directly. Sincerely. Okay, so a fairly innocuous letter. And I've shared that with the other side. Okay, don't do that. Don't send this letter because it's full of all sorts of interesting metadata. So we'll start by looking at all the markups. So we know this is being sent by email. There's an email address that's currently in here. This might be a personal email address that you don't want disclosed. There was some sort of negotiations going on here. That you didn't know about because you're on the other side, but they've been inadvertently disclosed. You've got an early draft of the first paragraph. Okay, that was deleted. You've got a comment here from this Wilma person, whoever that is. We've got all of this interesting text which has been deleted. Thank you for your letter, and your letter request to disclose confidential information. Cannot do this. The information is sensitive, publicly disclosed at the end of January. Furthermore, we've not come. There's a very negative letter here, okay, that has been deleted. You've also got a personal phone number here. And then you've got all these interesting comments up here. So let's have a look at some of these comments. How does this impact our negotiations? This is contrary to law. We cannot facilitate an illegal activity. Disparaging comment about the person is being discussed, whoever John Mortimer is. Lots of interesting things. Oh, there's even this. What's this? Oh, an error not detecting that the invoice would end up having this a very, very adverse comment here, and it has been removed, but it's still there. So this might be problematic for the case and the file. If I go to file and I look at info, this, by the way, is Word in the 365, Office 365 thing. So here's information about this particular file, and we can see more information, how long the total editing time was on it, but I know that I was billed for 3 hours, yet only 184 hours are spent on it. And got a bunch of interesting dates here. Oh, I know it was last modified in 2015. So, but the date on the letter was 2013. What does that mean? I know that this Martin Frobisher person was involved in drafting the letter. So there's more information in this metadata that creates an interesting picture. What does it all mean? I have no idea, but it's very interesting. So you probably want to cleanse it. So the way in which you would cleanse it, okay, first of all, you could go in here and accept all the changes, but I don't think that cleanses it because it's already been accepted. So what you want to do is in the information thing, you want to, first of all, inspect the document. So check for issues. Let's start with inspect the document. here's a bunch of things. So comments, revisions, versions, these are all things that you want out of this document. There's a lot of things in there. Some of them are not in here, but you, as a matter of practice, you want to clear everything out. Okay, so I've inspected it. Oh, sorry, I want all of that inspected. Sorry, I'm ahead of myself here. So you want all of that inspected. I should have not done that. Okay, so inspect. So you can see it's identified all sorts of issues. Okay, and it's giving you the option to remove them all. For some of these other ones, like the XML data, there's some in there that should probably be removed. So let's remove what we can. Okay, so now reinspect. So this, oh, there's still some stuff there. Okay, so that's better. So, oh, inspect. So there's still stuff up here. Okay, revision marks are still there. So let's close that. Let's go back to the document. What revision marks are still here? We've got this one here. So we can accept that change. And now it's gone from the markup. Let's go back to info and make sure that that's gone. Okay, inspect everything. It's cleansed. So now, if I look at this document, all markup, there's no markup. Okay, so that's good. And what does the info say? You can see that the total editing time now is 0 minutes. So now all that is no author, no modifications. Okay, so now there's absolutely no metadata of interest in that file. So now I can save it, and that's the one I would want to send out or share. Is that an onerous task on the part of the practitioner? Absolutely. Is it something that's necessary in all cases? It probably depends on the degree of contention or the sensitivity of the document involved. If I were doing it for legislation purposes, I wouldn't do it because I actually use some of that information. So it's really up to the practitioner to think what needs to be removed and what needs to be retained. But if I'm dealing with a litigation matter, I would think that the matter is sensitive. I would probably want to be very formal and remove what metadata I can so that there is no inadvertent disclosure of sensitive or confidential information. Are there any questions with that exercise?
Hi, Ian.
Hello.
Smoke again. So if, and maybe this is just my technology knowledge. If you save from a Word document to a PDF, can you talk about the effect?
Yep. So, oh, I just turned off the share screen, but that's okay. And I'll turn it back on again. Okay, so let's go back to this interesting and upsetting letter.
Not saving that. I'm saving your. Just so you know.
Just give me a second here to figure out what I'm doing. Okay, stop share. And be up here. And I'm just reopening this document. So we have the Word document back open again, okay? This, as you may recall, is actually the offending document. Okay, and that, okay, so this is the offending document. What I'm going to do is just generate it into a PDF. So file. We'll just save it as a PDF. Can you save it as PDF? There's my USB drive. Okay. Here's PDF. So it now should be saved as a PDF. Okay. And it is. Just drag that over to the desk. So there's my PDF document. Okay. What are we looking at? So we're looking at it in what program? Looks like Adobe Acrobat. Maybe.
I can't see that.
Oh, can you see? Can anybody see that?
I can just see your original Word file.
You don't see the PDF one. Okay. I'll do a
You
quick
might need to.
share screen.
So if you go into presentation, I think you'd be able to see maybe, your currently in two,
There it is.
like screen one.
Here it is. Okay, so can everybody see that one now? Okay, so this is, I'm not sure what program this is. Looks like it's an Edge. I think it's Edge. Copilot, whatever that is. I'm not familiar with this program. And I'm not sure I can actually cleanse it. So do you have Acrobat on this one? No. So I don't have Acrobat. What you would do in that earlier slide, the one with the instructions for the various software, you could go to that and there'll be instructions on how to cleanse it in PDF format. So if you go into the PDF format, you can cleanse it of all the metadata. And I'm not sure that the history of the track changes will be in that document. But that would be my approach for cleaning up a PDF document.
Okay.
Does that answer your question? Yeah. Okay, national security cases. So we have 4 minutes or so, 10 minutes. What I will do is just briefly go through them because they're quite long, and you may or may not find them of interest. And what I will do is just do that.
The green, at the bottom of the screen, I'll give you some options on what we want to share. There you go.
Oh, that one. Fix that. Full presentation. That one. So here we are back at the exercises. And these are the national security cases, which I used to have on this slide before, and I think they're still relevant because it's not something you would normally think about in the practice of law, and I certainly don't run into it, but you never know. So in this case, this is a federal court decision, and we're dealing with associated data and creeping into the realm of CSIS and terrorism. So a person of interest subject to investigation. So we're dealing with associated data. So it's legality of retaining non-threat information and third-party information. So we're getting very much into privacy issues here. Third-party information, meaning information unrelated to the threat, is frequently collected through the operation of warrants. The court is concerned about the retention of such information because it is not target threat related. Warrant conditions oblige CSIS to review third-party information it has collected in order to assess whether or not it falls within the conditions, parameters, and thus whether or not it can be retained. So very much a type of metadata, for example, retained by government. If you think about that in the case of Facebook or metadata, Facebook, you realize that this is also a matter of concern with respect to the data an entity such as Meta retains about the associations of its users. So every time you friend someone or comment on their post, that information is being recorded by Meta. And what they're doing is constructing a network of associations between you and others. And that, of course, is a standard technique in counterintelligence, but here it's being used for commercial purposes. There is a bill, a federal bill currently in the works dealing with artificial intelligence, and I think in part it deals with some of that. But it's very friendly towards entities such as Meta. The artificial intelligence aspect is very interesting because that is also the tool that's being used to process big data to make the inferences and the probabilistic relations between the different types of metadata. CSIS approach to metadata. So from this case, it's collected, it's then accessed, and then it's created and retained associated data. So what does all that mean? If the content is threat related, both content and metadata are retained, or if the content is not threat related, content is destroyed, but metadata is retained. So this is what got them into trouble, because they're retaining the metadata, but not the data. Metadata originating from content unrelated to the threat for which the content has been destroyed is called associated data. CSIS retains all associated data it has collected for an indifferent period of time. And they have been doing it since 2006. So here's another example, USA National Security Agency database. It was revealed in 2006 by US Today, and Eric Snowden again it's even before Eric Snowden. So metadata for an estimated 1.9 trillion phone calls made by the 4 largest US carriers from as far back as 2001, pre-9/11. Data is believed to be retained for at least 5 years, believed. Caller, receiver, date, time, length, call, etc., but not the contents or call of transcript. Traffic analysis and social network analysis. This is its nodal analysis I was alluding to earlier that Meta uses. Not to be confused with NSA warrantless searches. There's another thing called Marina here, another database for intercepted internet metadata. This is stored for up to a year. It was revealed by Snowden. Pattern of life analysis. US citizens are not exempt as metadata is not considered data under FISA. Some of you may recall the FISA courts. Sweden, tied-in traffic database. UK has an interception modernization program. Seems like everybody's in on it, big data. Back to X. So you can read this at your leisure. It's kind of interesting. Lots of X's. This has been security redacted. So here's a summary of the issues. I'm just going to skip through that because we're now starting to go over time. There's another case here I want to draw your attention to, Liberty, and should be GCHQ. And it's an interesting case. It's a response to the Snowden allegations. And I think you will find in the courts actually admonished the intelligence services because they were basically flouting the law. Heavy privacy implications. So that's it for the presentation. And you're certainly welcome to look at the national security cases at your leisure. And if there are any questions, certainly do pass them on to Jessica, and we can try and respond to them. Are there any last questions? Any comments from anybody? Okay, well, I hope you've enjoyed it and you found this of interest. I certainly found it of interest. So have a good day and thank you very much for attending my CPD.
Thank you, Ian.